Okay, so welcome everyone to our first Ethics Center event of the fall semester. I'm Andrew Fiala, and I'm the director of the Fresno State Ethics Center. We do events like this, about a dozen of these kind of events every calendar year, every academic year. And this is our annual Constitution Day event. We've been doing this for many years, collaborating with the Civic Ed Center. So I want to just start off by saying to Steve Morris and John Minkler and those folks at Civic Ed, thank you again for all your partnership on this stuff over the years. And I also want to say thanks to the Fresno State Alumni Association, which set up the Zoom, and also to Eduardo Tovar, who is our student assistant this semester. So all those thanks out of the way. Just very quickly about the Ethics Center. So we do basically events like this every semester and the goal is, the mission is to have students in the community think and talk critically about issues that matter. And we do all kinds of stuff across the board. Our next event will be on October 5th, and it's going to be about a holistic view of mind and body with a philosophy professor from Colorado speaking, Candace Shelby. And as you know, today we're doing a Constitution-focused thing. September 17th is Constitution Day in our country. That's a commemoration that happens every year. So our topic today is the origins of the Constitution. And what's going to happen is we have with us Justice Don Franson, who is going to sort of lead our conversation. He'll talk for 10 minutes at first, and then we'll have some panelists respond. And then that'll happen again. And then towards the end, the last, hopefully 20 minutes or so, we'll have a lot of opportunity for conversation from the audience. So we'll use the Q&A function or the chat function. If you have a question, post it to chat and Q&A. And let me just remind you, this is an academic event where our goal here is to model civility and civil discourse and to think critically. So, use your best behavior in the Q&A, if you don't mind. We're going to disagree about stuff, and that's okay. So let me now introduce our panelists and our keynote speakers. So I'll begin by introducing Justice Donald Franson, who graduated from the University of California, Berkeley, and then got his law degree from the UC Hastings College of Law. He was deputy district attorney in Fresno County, and then went into private practice, where he practiced civil litigation, including commercial and agriculture litigation, until he was appointed to the Superior Court by Governor Schwarzenegger in 2005. In 2010, Justice Franson was nominated by Governor Schwarzenegger as Associate Justice to the Court of Appeal, the 5th Appellate District. And of course, he was confirmed in that role. Before his initial judicial appointment, he was involved in community groups, including president of a fire protection district, board member of the Fresno Regional Foundation, Central Valley Foundation. And since he's been on the bench, he has lectured and participated in numerous panels and discussions of litigation-related topics. He's taught trial advocacy and civil litigation at the San Joaquin College of Law, and he's presently a member of the Judicial Council Advisory Committee on Civil Jury Instructions. And I just, on a personal note, I've gotten to know Don over the years working with the Civic Ed Project, and he's just a kind and generous person. And so, Justice Franson, thank you for joining us. And before I turn the floor over to him, let me introduce Dr. Stephen Morris, who is the CEO of the Civic Education Center here in Fresno. He's worked in a variety of capacities at schools, public schools, charter schools, private schools. He's been around the block in terms of education. He has his doctoral degree from Fresno State, where he wrote his dissertation with this beautiful title, School Choice, Segregation, and Equity, California's Charter School Mission, Market, and Voices of Charter School Leaders of Color. And I've also had the great pleasure to work with Steve over the years. So Steve, thank you for joining us. And then we have with us Moira Harada, who taught law for 7 years at CART, the Center for Advanced Research and Technology. She helped pilot a civic education project there, working with Steve Morris and the Civic Education Center and the Fresno Bar Association. She received a Liberty Bell Award from the Fresno Bar Association for furthering legal education in the community. And she was also able to participate in the Street Law Supreme Court Institute in Washington, where she met Supreme Court Justice Sonia Sotomayor. And she got to do a deep dive into teaching about constitutional law. She's no longer working as a teacher, but making a transition to get her certificate as a paralegal. Moira, thank you for joining us. And then finally, our third panelist, we have Jesus Camacho, who is a Fresno State philosophy major in our pre-law program. And he hails from Tulare, California, where he, before coming to Fresno State, he attended the College of the Sequoias, where he got an associate degree in philosophy. His plans after graduating are to go to San Joaquin College of Law. He's currently working on an internship with the Hernandez Law Office under Joshua Hernandez. And he's also currently working with Moot Court on campus. And I think he just came from a meeting of Moot Court, if I understand correctly, Jesus. So anyway, that's our panelists. First up, we're going to hear from Justice Franson. So Justice Franson, again, thank you for joining us. The floor is yours.
Thank you. Thank you, Professor Fiala, for the kind introduction. The United States Constitution is referred to in the mainstream news and social media today more than any other time in my life. From freedom of the press, speech and religion, abortion rights, voting rights, gun rights, climate change, immigration, healthcare, and affirmative action, and more. Everyone thinks they know what the Constitution and the Bill of Rights mean, even if they haven't read them since the 8th grade, if at all. But the real question is, how should we decide what the various provisions of the Constitution mean? How important is the meaning of the original wording when weighed against the practicalities and realities of everyday life in our country? Oliver Wendell Holmes, recognized as one of the great Supreme Court justices, once wrote, "The life of the law has not been logic, it's been experience." Supposedly, this phrase is supposed to remind judges and other lawmakers to never let the law lose touch with the needs of ordinary people. This notion was known as a, quote, living constitution, confirmed over 200 years ago by Chief Justice John Marshall, Thomas Jefferson, and others, and acknowledged by many Supreme Court opinions and academics for the first 200 years after the Constitution was adopted. Beginning in the early 1980s, some legal scholars and lawyers came up with an alternative interpretation of the Constitution, the Originalist school of thought. The central claim of Originalists is that today's standards of justice cannot take precedence over the values and ideas that prevailed in 1789, when the Constitution was written and ratified, or in the words contained in the Constitution or amendments. My talk this evening tries to address these 2 points of view, using the Second Amendment as an example. If we can show slide 1. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I'll show you those words later on too. First, a brief history review. Remember, history is what we choose to remember at any given moment. Some history is later rediscovered and forms the basis for changed attitudes and perspectives. But to be authoritative, the history and factual basis must be credible. It's important to distinguish between historically confirmed facts, alternative facts, and opinion. Think of the 1760s and the events leading up to the split from England. Britain wants money to repay the cost of the 7 Years' War with France. They start imposing taxes and duties on Americans. We have taxation without representation, as we all know. When some colonies revolt and protest, the British increase the aggression and require the colonies to feed and quarter the British troops in private homes and taverns. 1775, shots are fired and militiamen are killed at Lexington and Concord. The Second Continental Congress starts raising the Continental Army. George III declares the United States in a state of rebellion. In July 1776, we have the Declaration of Independence. A union or confederation of the 13 colonies is formed. In 1781, the British surrender at Yorktown and our nation is born. The Articles of Confederation are ratified based on their experience with the British Parliament, the King, and their knowledge of European history. The leaders are leery of any type of national government, so they make it very weak. The states were also encouraged to write their own constitutions or declaration of rights. The Articles of Confederation did not allow Congress to collect taxes, defend the country, or pay the public debt. Government troops refused to swear allegiance to the United States, only to the sovereign states. It gave as little power to the central government as possible. Congress represented the states. The post-war economy was a mess, however, and showed the need for an effective national government. This led to the calling of the Constitutional Conference for delegates to discuss revising the Articles of Confederation in the spring of 1787. But the delegates quickly decided that revision was not enough. The Constitutional Convention met over the summer of 1787 and eventually ratified the Constitution in 1788. James Madison was the main author. The Constitution was meant to be a working document, a statement of positive laws, plain, brief, strategically vague in some places to give play for future circumstances, and because they couldn't agree on some serious issues like slavery. It contained deliberately open-ended guarantees. It was not a specific code of conduct. It contains values such as religious freedoms and separation of church and state that may conflict with other values of interest and have to be reconciled. In the end, it was a hybrid structure. There was a division of authority among local, state, and national governments, and an independent judiciary with final authority over the legitimacy of all legislation, national, state, and local. The two debating camps were the Federalists, who wanted a strong national government, and the Anti-Federalists, who did not. They did not trust the national government. The two factions have existed throughout our history and remain dominant today. The Anti-Federalists were in the minority, but very vocal. They promoted conspiracy theories and fears of change. We can show slide 4. The two sides, the Federalists, made up of George Washington, John Marshall, John Adams, Alexander Hamilton, and James Madison. Later, Abraham Lincoln, and the Republican Party held this position until the 1980s, 150 or 200 years later. Today, eventually, the Democrats are considered the Federalists. The Anti-Federalists were essentially anti-national government. Thomas Jefferson was a main proponent, but later Jefferson came over to his side and started espousing some Anti-Federalist arguments. They were made up of agrarian interests that supported slavery and eventually became the Jacksonian Democrats and eventually Republicans of today. Both factions support the, quote, liberal tradition, and that meant a Republican form of government, meaning popular sovereignty, market economy, and the rule of law. There is no single source of sovereignty in the Constitution, but Article 6 says that the Constitution shall be the supreme law of the land. In the end, it's all a matter of interpretation and the debate about federal versus state sovereignty that has never ended. For our purposes this evening, it's important to distinguish the regular or Continental Army and state militias and how they were viewed during the Revolutionary War. The Army was barely paid while the militia was voluntary. State militias were trusted, but the Army was not. Without the state militias, the colonies would not have won the war. So let's address the Bill of Rights. It was not really brought up at the Constitutional Convention, but 8 states already had them. James Madison felt they were not necessary. Jefferson was in Paris at the time, representing the United States interest, but not at the convention. He strongly urged having a Bill of Rights since Congress was given explicitly broad powers that needed to be held in check. Jefferson and others were leery of federal power. Jefferson felt the primary threat to individual rights came from the government. Madison eventually changed his thinking and drafted the Bill of Rights in the spring of 1789. They were drawn from the Virginia Constitution. Eventually, the Bill of Rights was passed by the first Congress in 1789. Madison's first draft said, quote, "The right of the people to keep and bear arms shall not be infringed. A well-armed and well-regulated militia being the best security of a free country." The Senate reversed the two clauses in Madison's draft, which grammatically clarified the rationale and basis for the right to bear arms, that is, to form an effective state militia. If we could show this first slide again, Andy. We have the final draft, which is being shown to you now, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In looking at that paragraph, the preface or preamble states that the preservation of the militia is the primary purpose, meaning a well-regulated militia being necessary to the security of a free state. And the operative phrase, the right of the people to keep and bear arms shall not be infringed. And in the language at the time, keep and bear arms was a military term, not a civilian term, a military term. The primary role for the militia was to assure a free state without the threat of a standing army and the fear that that standing army caused. Some state constitutions expressly protected civilian use of guns. But even with this knowledge, the drafters of the Second Amendment make no mention of civilian use of firearms. If the framers wished to expand the meaning of the phrase bear arms and have it include civilian possession and use, they could have easily done so, since it was done in several state constitutions. A fair reading of the prefatory clause of the Second Amendment makes clear the framers' single-minded focus in crafting a guarantee to keep and bear arms was on military uses of firearms, which they viewed in the context of service and state militias. The Constitution also provided that all officers of any militia shall be appointed by the states, not the national government. Soon after Congress passed the Second Amendment, they also passed the Militia Act, which required every able-bodied white male 18 to 45 to enroll in a state militia, purchase a gun and equipment necessary to perform their military duties. This made gun ownership a legal obligation, not an individual right, and is consistent with the emphasis on the military use of firearms in the Second Amendment and control of militias. Over the next 200 years, the Second Amendment was never understood as placing any limit on state, federal, or local authority to enact gun control legislation. The 1939 Supreme Court case of United States versus Miller, unanimously endorsed this militia-based understanding of the Second Amendment. If you could show slide 2. The main question debated today is whether the Second Amendment is for 1, the right to a well-regulated militia, or 2, the individual right to bear arms, or 3, the right of self-defense. If it was for number 1, then governments are free to pass and enforce individual gun control laws. If it is for numbers 2 or 3, no gun regulations are allowed except in very narrow circumstances. We can break for questions or comments from the panel.
Yeah, thank you, Justice Franson. This is fascinating. So we have some time for conversation from Moira, Jesus, or Steve. If one of you guys want to lead it off.
Sure, I will. I always find this discussion fascinating. When I would teach my kids, we'd use political cartoons sometimes, and one of my favorites was 2 statues, and it's like one, what the founding fathers thought the Second Amendment meant, and it's a militia guy with the one gun that takes 8 minutes to reload and all that stuff like that. And then there's obviously the hyperbole of the opposite of how people want to view the Second Amendment, and it's this guy with like an AR-15 and massive amounts of, bullets and all of that stuff like that. And I always wonder where the line gets drawn, I suppose. If we're saying that the Constitution never intended for individual gun ownership necessarily to be protected, then I don't know, what are your thoughts, Judge Franson, on is there a protection at all in the Constitution for individual gun ownership? And if we're going with the interpretation number 2 or number 3 that you had on that slide, is there any limit to it?
There, and I'm going to get into, that's the topic of my second part of the talk, that I get into it. But if you look at it, simply what the wording is, that, like I said, there's nothing mentioned about the individual right to have a gun. But you have to look back at the time. People used guns for all kinds of things because they lived in the country. I mean, that's how they got their food. They went out every day hunting. And kids from the time they were born, knew how to handle a gun, but not for self-defense reasons, even though they had them for self-defense. They lived out in the country in cabins, and they had to protect themselves against animals or just bad guys that would come by. But the idea is, under the original thinking, is you can regulate it. You can say you can have certain types of guns and not others. You have to look back. All they had in those days were pistols, muskets, and Kentucky rifles. They didn't have AR-14s and Uzis and all the other stuff that we have now. So it's hard to relate to it. But I don't think there was any idea that they were going to somehow ban those. But the idea, because it's not under the Second Amendment, from my reading of it, it allows you to pass reasonable regulations without fear of violating the Second Amendment. And I think that's the key. But things have changed, and that's where we are.
So that actually, sorry, one more question.
And then Moira, and then we'll bring Jesus in. So go ahead, Moira.
You talked about the originalist perspective versus the living Constitution perspective. Right. And it's interesting to me that from what you're saying, it sounds like the interpretation for number 1, the idea that it's for the well-regulated militia, would actually be more of an originalist interpretation. And yet the justices who tend to proclaim themselves as originalists tend to be of the different interpretation of the Second Amendment. And what are your thoughts on that?
I'm going to address that very topic later on. And you're targeting exactly what it is. Scalia, who was the author of that, has been roundly criticized because strictly originalist interpretation would say exactly what you said. It seems pretty clear. But Scalia, in his decision, he cited 1600 English law to support it. He didn't cite what was going on in the United States in the 1780s and 90s about what he looked back at Blackstone's commentaries from England, and he really had to go back for a long time. And that's why he's been roundly criticized by a lot of people. Essentially the ends justify the means. That's what the critics say anyway. So, there's a whole argument to that the originalist or the idea that he, because he thinks society has changed, we need to adopt this new Second Amendment reading, which is really kind of a living constitutional argument, because he's adopting it to today, where he thinks everybody's in danger. So there's a lot of conflicts in all that, just like you pointed out. So, Eduardo?
Jesus, what would you like to add to our conversation?
So on the topic of this, I kind of had a question of, have you noticed any trends in the court's decision to kind of expand the limit of Second Amendment protections, or to limit expansion, with decisions such as New York State Rifle and Pistol Association and versus the Bruin decision?
I'm going to talk about that too, towards the end of my talk. And essentially what those cases say started with Heller, and then we thought that was pretty bold. And Heller even said in there, I think Anthony Kennedy got him, from what I've read, who was a very moderate member of the court, he got him to to add some stuff in there, Scalia, so he would sign on to it. And they were, by what we're saying today, we're saying that there's nothing to prohibit reasonable restrictions, such as bringing guns close to school grounds, close to government buildings, large sporting events, and all those in room for legislatures and local governments to pass reasonable gun laws, taking into consideration the safety of the public. If you go to the new case now with Clarence Thomas, he has thrown that out. You're not supposed to balance anything against the right of the Second Amendment to protect all people carrying guns in defense of their home. And then he's expanded anywhere. So when you see on TV and these riots and protest stuff where everybody's got these firearms and body armors and they're just walking the streets like that, that's what these open carry rules are allowing. And right now, the current state of the law, that you can't put any restrictions on there. And they're trying to get something for schools, but we don't know if that's gonna pass muster. I mean, I certainly hope so. I mean, we've had enough tragedies, but those are the big debates right now. Clarence Thomas used to always complain that the Second Amendment was some second-tiered constitutional right. Well, his new decision came down, as people say, it's got more oomph to it now than any other constitutional right, the way that was written. And it was a 6-3 vote, so it's not going to be changed anytime in probably my lifetime. So,
Hey, Jesus, any follow-up?
I really thought that was a really great response, but don't you think that's a bit, as you explained it, kind of hypocritical, that if we're going back on precedent or previous rulings now and then just adding to these protections, don't you think it's a bit hypocritical of the court as it stands to be changing precedent?
yes. I mean, what they've done is essentially overturned 4 very solid Supreme Court precedents on this topic. But right now, those don't seem to count much. You know, you watch the hearings for the confirmation and everybody all says that they respect precedent and they observe it and they think about it. But there's 4 or 5 factors. If you're going to overturn precedent, there's 4 or 5 established factors you're supposed to consider. And so they, pass on it and say, but I'm going to keep an open mind. And now we see what that means. So I think people are getting kind of jaded about what these Supreme Court confirmation hearings, what they say, because they're all in code speak, so to speak. And if you're for the nominee, you're for the nominee, and if you're against them, you're against them, and there's nothing in between. So which I'm not too sure is a very healthy way to do things, but that's where we live. So
just to make sure we keep our panelists involved, Steve Morris, if you have a comment, and then I'd also, Justice Franson, there's a comment in the chat that asks, hopefully at some point you can give some references for more information. Where can the person says, where can we learn more information about the facts and the history of this discussion? So, but Steve, anything you'd like to add at this point?
Yeah, there's a couple things. One, there's also another comment or question, an anonymous attendee. I think it's probably one of my relatives. No, just kidding. They're basically asking if the issue was, Judge Franson, as you spoke, if the issue was focused on self-defense, wouldn't that issue get lost in the translation between a militia and individual rights? Technically, gun ownership for militia is for defense. So that idea of self-defense and the militia is important. And how does that translate today?
Well, right now, they just ignore the militia requirement. I mean, they don't even, and I'll explain later, the NRA and everybody from the gun rights advocates, they don't even mention the militia. That's kind of been written out of the whole requirement. And that's why they have a pretty free slate to write on. But the idea of self-defense, that is a separate kind of a separate issue, but the question is, the old days, it was self-defense of your home. You were not allowed to take it out in the public in self-defense unless you had a permit to carry. And those were very regulated and they were hard to get. And now, as you know, you don't have to have one, so everybody's walking around. It's not like they're packing a pistol in their pocket or their holster. They're walking around with high-powered military weapons. So, but it gets messy, and I think the approach I would like to see is people being intellectually honest with what they're saying and not just skipping over a few small requirements. So, but that's just my personal. Unfortunately, on a state court, we don't have to rule on this stuff. So that's why I don't think I'm speaking out of school, to be honest with you.
Go ahead, Andy.
Steve, quick final question, and then we'll ask Judge Franson to take us to the second half of the talk.
Cool. I grew up in Kansas. This is not my question, Andy's statement. No, no. I grew up in Kansas, and going to high school, we had folks coming to school with shotguns in the back window, right, of the cars. In the 1960s, when the Black Panther movement was real pronounced in our country, the issue was, can African Americans legally carry their rifles in public? And it caused a big disturbance with the FBI and with everyone else. That you saw armed militia, that's what the Black Panthers were in some cases, other than a social organization for feeding and job training. They were a proclaimed militia.
Right.
That openly carried weapons in the United States. And we began to see the laws change shortly after that. Talk to me about how you see that issue of the Black Panther movement, self-proclaimed militia, United States, and then this idea that, I guess in some communities, it's okay to put a shotgun in the back window of your car and drive to school with, or it was back in the 70s.
Well, that's when things, and I get into this a little later, that's when things really started to change. In the old days, especially out in the West and these other places, everybody had a gun in their pickup truck. I mean, it was just standard. It wasn't for self-protection. It was because they'd be driving down the road and they'd see, some animal out there that they wanted to get, or shoot some cans or go target shooting or something like this. And then when, the violence and the riots and I talked about this, that's when people started actually to have some real fear, and some of it was exacerbated because of the press and a lot of the stuff that was going on, but it was true fear. I mean, you saw in the news every night the riots. I mean, when I was at Berkeley and they had bombs going off and tear gas and things like that, people were fearful. So as he says, there's not a simple answer on the whole thing, but if you look back and take a big view, you can see how things kind of line up. So,
Judge Franson, I wonder if we can ask you to take us into the second installment of your talk. And we did have one, as you're getting ready for that, we had one more question from Samantha, who was wondering about vagueness. How vague are these amendments, and then does that leave it open for interpretation? And part of the question is, could it ever be perfect where you wouldn't have a conflict of interpretation?
Well, the question is, if it's vague, then you fall back on the same rules of interpretation that I use when I do the case. If it's vague, then you look at the history, you look at what's going on in the world today. But if it's not vague, and I don't think the Second Amendment is vague, if you break it down and read it with the understanding of why it was written that way and how they cleaned it up with the preamble and then the operative phrase. And if it's clear, then you follow what the word says, unless that wording would come up with some absurd result. And I don't think it's an absurd result what they have. So if you apply the standard rules of interpretation, which I use every day in my job and the Supreme Court's supposed to use, I don't think it's vague. But if it is, then you look at what was going on in the country at the time, and you look at other things that will show what the founders were intending. And I think the history shows that the founders were intending to give the power to the state militias to protect them against the federal government, because the histories of Europe and England, where they had monarchs and dictators, the government was not nice to those people, and the Americans, colonists, they realized that, and they wanted to protect themselves from the national government. You know, that was the biggest threat to their liberty. So that's what I got. Okay. Legal and political history happen in cycles. Historians refer to a progressive cycle that began during the Depression and the New Deal and continued with Brown versus the Board of Education in 1954. Brown overturned Plessy versus Ferguson, which upheld racial segregation as acceptable in public schools as long as the facilities were separate but equal. But Brown did not rest its decision on the intentions or language of the original Constitution, but instead relied on recent sociological studies that segregation by race was inherently discriminatory. This began a shift in the progressive/liberal direction that lasted for nearly 30 years until the 1980s. It was based on the belief that federal judges were interpreting a, quote, living constitution. This obligated them to adjust their evolving standards of justice, not be wedded to the past, and not lose touch with the needs of the ordinary people. History and social evolution supported this change of thinking. Many conservatives argue that the founders were a unique gathering of infallible geniuses and should never be second-guessed, no matter how much society changes over time. If you can show us slide 3. This is what Jefferson wrote in 1816. Some men look at the Constitution with sanctimonious reverence, too sacred to be touched. They ascribe to the men of the preceding age a wisdom more than human, and suppose what they did to be beyond amendment or improvement. I know that age well. I belonged to it and labored with it. It served the country well. But I know also that laws and institutions must go hand in hand with the progress of the human mind. We might as well require a man to wear the coat which fitted him when as a boy, as to have civilized society remain under the regimen of their barbarous ancestors. John Marshall, a member of the Virginia Ratifying Convention and later Chief Justice of the Supreme Court, said essentially the same thing. Examples of progressive interpretations or a living constitution include the sanctioning of interracial marriages, the broadened definition of free speech, allowing the sale of contraceptives, the right to abortion, private sexual relations between same-sex couples, gay marriage, women's rights, workers' rights, healthcare, and affirmative action. From 1791 to 2008, 217 years, the Supreme Court did not strike down a single federal, state, or local gun regulation. So what happened to the progressive swing? In the late 1960s, when I was in college at Berkeley, protests broke out over the Vietnam War, civil rights demands, and other social causes. The fear of violence and rising crime spread the country and continue to today. Gun groups like the National Rifle Association changed its focus from promoting marksmanship, sport shooting, and gun safety to a political organization in the 1970s in response to perceived attacks on the Second Amendment. Its website says it is now a civil rights organization and protector of the Second Amendment. By the 1970s, the NRA started arguing the Second Amendment conferred an individual right. The plaque at the entrance to the NRA headquarters now simply says, "The right of the people to keep and bear arms shall not be infringed." The preceding clause about service in the militia was deleted. As early as 1980, the Republican platform proclaimed, quote, "We believe the right of citizens to keep and bear arms must be preserved." Courts remained unreceptive to this new and novel argument, but the gun rights lobby and supporters built an effective and sophisticated political infrastructure, outreach, public relations, and advertising campaign to advance their cause. Chief Justice Warren Burger, a very, very conservative Republican, called this new interpretation of the Second Amendment one of the greatest frauds on the American public by a special interest group that he had ever seen. In the 1990s, the NRA paid a selected group of lawyers to write 300 articles for law reviews, all designed to create an alternative body of legal scholarship in support of individual gun rights. There was no peer review or editorial screening for the historical accuracy to support an unambiguous personal right to own and use guns. Also, in the last 20 years or so, especially after 9/11, there has been a promotion of fear and paranoia around the country. Certain groups are targeted, such as immigrants and foreigners, including the government itself. Government itself as coming to menace or hurt you or your family. In the mid-1980s, Robert Bork and Antonin Scalia started promoting the doctrine of originalism. Their doctrine was that the true meaning of the Constitution had been perverted by liberal judges with their expansive agendas. Instead, it should be based on the original intentions of the framers. The core claim of originalists is that contemporary standards of justice cannot take precedence over the values, convictions, and ideas that prevailed when the Constitution was written and ratified. Some scholars and judges argue that originalism was simply a pretext for achieving conservative goals on issues such as abortion, religion, voting rights, election, environmental regulation, and guns. So how did the originalism gain support? One source was the Federalist Society for Law and Public Policies, founded in 1982. It advocates the originalist interpretation of the Constitution. It is funded by various corporations as a network for conservative law students, lawyers, and judges. In 1985, President Reagan's Attorney General Edwin Meese publicly endorsed originalism. It grew rapidly under Presidents Reagan, both Bushes, and Trump. It is funded by corporate interests such as Google, Chevron, and the Koch brothers. All 6 Republican members of the current United States Supreme Court are still active members of the Federalist Society. The 3 most recent appointments came from a list of potential nominees prepared by the Executive Vice President of the Federalist Society, pretty much guaranteeing which way they would vote on major constitutional issues, including gun rights. In law school, I learned that many judges changed their perspective and judicial philosophies after spending some time on the Supreme Court. They grew into their jobs and no longer, quote, represented a narrow segment of the country or population, but instead considered everyone in their decisions from all walks of life throughout the country. As judges should, they kept an open mind. When their perspective changes with time, their partisan supporters were bitterly disappointed. Examples of Republican presidents who appointed such judges are numerous. Earl Warren, William Brennan, Harry Blackmun, the author of Roe versus Wade, John Paul Stevens, David Souter, and even Anthony Kennedy and Sandra Day O'Connor. Gaining a Federalist Society endorsement offered a way to protect justices changing their perspectives or minds once they join the Supreme Court. When judges interpret a constitutional provision, such as the Second Amendment, historical precedent says they should also consider whether other conflicting constitutional provisions should be examined and balanced against the provisions you are looking at, such as the First or Second Amendments. 200 years ago, John Marshall said it is the, quote, whole Constitution that we are interpreting, not just one clause or amendment. This whole Constitution idea is means we must balance and insert order, security, fairness, the general welfare, and equality into the equation. The Constitution does not give simple rules for deciding hard cases and issues that get more complicated and sophisticated with time. The first big change was in 2008 with Heller versus the District of Columbia. Heller discarded the militia component, as I have explained, which was the rationale and basis for the right to bear arms. Heller ruled that citizens could own and use firearms in self-defense of their homes. Heller held that the Second Amendment protects an individual's right to carry any weapon typically possessed by law-abiding citizens for lawful purposes, because such weapons were what citizens brought with them to the militia in 1789. Heller was written by Justice Scalia, as I said. He overturned 2 centuries of legal precedents to find the Second Amendment guaranteed the individual right to bear arms to protect homeowners and their families. Heller was not really a surprise, given the change in the makeup of the court and the decades-long public relations campaign and advocacy of the NRA to make gun ownership a right of citizenship. Heller was to the conservative cause what Brown was to the liberal progressive cause. Just as the NAACP had waged a long legal and political battle against racial segregation that culminated in the Supreme Court decision that ended segregation by race in public schools, the NRA waged a civilly and more heavily funded campaign to remove all legal restrictions on the right to purchase and own guns. One of the great fears was that federal agents were coming to take your guns. In the 1960s, 50 to 60% of the citizens favored an outright ban on handguns. By 2008, 73% believed the Second Amendment guaranteed the right of Americans to own guns. Nearly a 50% swing in the polls in favor of the Second Amendment protection of individual rights. Justices and scholars argue there is a more reasonable, quote, originalist interpretation of the Second Amendment. And that is, the Second Amendment was adopted to protect the right of the people of each state to maintain a well-regulated militia. It was drafted because of concerns that a national standing army might pose a threat to the security of the states. Nothing in the historical texts or arguments suggests any intent to limit the government's authority to regulate private citizens' individual possession or use of firearms. Although Scalia is known as a good writer and grammarian, reading Heller can be painful. Historians and legal scholars explain that this is because it is difficult to reconcile Scalia's originalist convictions with his political agenda on firearms. In their thinking, Scalia was committed to giving an originalist interpretation to a historical document whose words and historical context are contrary to the conclusion he was predisposed to reach. There is not a word in the Constitution that supports the Heller conclusion that the Second Amendment should be elevated above all other interests, such as the general welfare or public safety, to give an individual right to use arms in defense of their homes, let alone assault rifles. Scalia's preordained outsource forced him to do 3 challenging things. 1, show that the words of the Second Amendment do not mean what they say. 2, to ignore the historical conditions of his originalist doctrine purportedly required to emphasize. And 3, obscure his complete rejection of the accumulated wisdom of 4 Supreme Court precedent cases. Like the NRA, he simply lopped off the militia requirement as irrelevant. A recent 2022 case took a big leap forward from Heller. The State of New York Rifle and Pistol Association versus Bruin, authored by Clarence Thomas. It held that the Second and 14th Amendments protect an individual's right to carry firearms for self-defense outside the home. Thomas went way beyond Heller. He even refused to consider how government or public interests that justify gun regulations, no matter how compelling, such as for public safety, there is to be no balancing of other constitutional rights or consideration of the, quote, whole Constitution. Originalism is the reaction to the living Constitution, first espoused by John Marshall and Thomas Jefferson 200 years ago. Now, with the Supreme Court in the middle of every political dispute, it is no longer above the political fray. With the current makeup of the court, I personally don't see any way the tide will turn on originalism in my life. But back to the main question posed earlier on slide 2, if you can show that. Is it fair? Is it a fair reading, slide 2? Is it a fair reading for the Second Amendment to be limited to the right to a well-regulated militia, the individual right to bear arms, or the right to self-defense? I hope I prompted you to consider or reconsider this question here this evening, and I want to thank you for your attention. And now the time for more questions and discussions. Thank you.
Thank you. Wow, you were powerful in this. You declared your opinion. I wonder, maybe to get our comments, maybe we could start with our student, Jesus first, and then hear from Steve, and then Moira, have you finish it up since you got to go first last time. So Jesus, let's bring you into the conversation.
Yep. Again, perfect presentation. I had a question on political trends. Political trends affect the Constitution's interpretation. Do you feel as the media and the current age politics diverge from the Constitution, or are we just seeing a court that doubles down on their own interpretation, contrary to what the majority of support is from the people?
I think it's a combination of both. I think that the media and really social media, for the most part, has really just taken sides on this. You know, if you watch the blogs and read what's on, social media, the conservative news, the Fox News of the world, they want to stir up fear out there. You watch some of those programs and you come away thinking there's riots in the streets and everybody's coming after you and everybody's got a gun and everybody's going to, threaten you. So I think that gets picked up and exacerbated a little, but I think it's a combination of everything. And then, the conservative wing of the country and the judges, they've been sitting around for 20 or 30 years, very frustrated by what was being enacted by the Supreme Court with all those progressive decisions over the last 20 years on all those social issues. Every one of them that comes down, they just are infuriated. So now they have their chance, and that's why they're coming on very, very strong, and they know they have the power. And so there's nothing holding back. So instead of doing things incrementally, if you notice that John Roberts didn't go along with the overturning of Roe versus Wade, he wanted to do it slowly because he didn't think it's healthy for the Supreme Court to just overturn precedent. And there was a way to decide that case without overturning Roe versus Wade, but he was left in the dust, and Justice Alito took over. So, that's why you're getting this aggressive stuff. One thing I wanted to mention before our time's up is where I got some of my information. I was a history major in college, and I've always read history. And the primary book that I relied on this is a book I read 20 years ago and reread, and it's called The Story of the Constitutional Convention. And it was written by a historian, Catherine Drinker Bowen. And it's kind of the big book. It was written for the 200th anniversary of the Constitution. It's a very easy read. It quotes extensively from notes. James Madison took copious notes of the Constitutional Convention. I'm not too sure how he could participate at the same time he was taking these notes, but a lot of it comes from what he was saying. The other one, there is a historian named Joseph Ellis, who has written extensively on colonial and revolutionary history. And he's come out called The American Dialogue, The Founders and Us, and another one called The Cause, which is the American Revolution. And he talks extensively about the militias and how the militias were really the favored group. And without them, they never would have won the war. Washington basically formed the original Continental Congress by signing on with the Massachusetts state militia when the British took on Boston and invaded. So that was all militiamen there. And so he ties it to the Second Amendment very, very clearly. I get a lot of emails from law schools that have been writing on the Second Amendment since the recent case came down. The dean at Bolt is very, very prolific and stuff. And so I read those when they come out and stuff. So that's where I got some of my ideas.
Judge Franson, thank you. I have a reading list that keeps growing. I never get to read everything. Yeah. Thank you. I'm wondering, Steve and Moira, maybe we could have you guys kind of go back to back and give us a couple questions and thoughts, and then have just Judge Franson respond. So Steve, why don't you go first, and then Moira, you can follow up, and then Judge Franson, you can listen to both and reply.
Thank you.
Judge Franson, I never get tired of hearing you. You always blow my mind with things I hadn't considered before. When we think about the vagueness of the Constitution, intentionally written that way, and Madison's role in keeping these notes, it's interesting to me that issues on slavery were decided through several Supreme Court decisions, and it enforced kind of the way society viewed it. Dred Scott, for instance, in 1954 versus Stanford,
Right.
basically considered African Americans subhumans, right? And
Or,
it basically
or property, basically.
Property,
Yeah. They didn't have a role in our
Mhm.
country because they were property. And that, that was thinking predominantly from the South when that was coming down, and that's where it was. And, if you look at our history, what was going on before the Civil War, what Lincoln was doing, and then you get into right after the Civil War, and then Reconstruction, and then when Grant left office, that's when basically the federal troops left the South. The Southerners were free to do what they wanted to do, and they kind of ran free for another 80 or 90 years till the Voting Rights Act in the 60s, and until Brown versus the Board of Education and stuff. So it's been up and down, and I think it's, history changes, and that's why I think Thomas Jefferson was right. Of course you have to move on, and hopefully people get smarter as we go on. I mean, but that's kind of what we're dealing with.
Yeah. Steve, thank you. I know there may have been more to your question. I'm keeping my eye on the clock here, and I want to make sure that Moira gets a chance to speak to us again. Go ahead, Moira.
So this might be veering a little off, but at one point you mentioned the idea that, so there's case precedent or stare
Right.
decisis, the idea that you're supposed to let the precedent stand. However, there has been a history of the court overturning itself.
Right.
And you mentioned 4 or 5 factors that usually goes into reversing a decision like that. And I was just wondering if you could expand on that, because I don't think that a lot of people are aware of.
I can't remember what those are, but I know that there's a couple of them. One, how long has it been there? 2, have people come to rely on it to a point where, it would be unfair to take that right away? Because most of the time when the Supreme Court is reversing itself, it's not taking away a right. We've never done that before. It's giving them an additional right that was deprived of them before. And as you know, overturning Roe v. Wade took away a right that women had been relying on for whatever years, almost 50 years since Roe was originally gone. So it's very unique that it's taking away a right that people had been come to rely on. So if you're going to go through those 5 factors, I think about 3 of them were totally violated when they did it. So, and they kind of came up with some reason they didn't address it. I think that Alito's decision came right at the beginning. He didn't even have to get into it because he said Roe versus Wade was wrongfully decided when it was issued. Move on from there and tell us what the right thing was. He didn't even really address that. But again, those were the 2 or 3 of those factors that were there, but I don't remember the other ones.
Judge Franson, I am keeping my eye on the clock here, and we got just about a couple minutes
Okay.
left. I want to just thank the audience and the panelists, and then maybe just invite you as a kind of conclusion. Are you hopeful about that? You said at one point I heard you say in your lifetime, the original.
I'm over 70, so I'm assuming I got at least another 10 years to go. With the age of the court and the conservative group now, Clarence Thomas is, I think, the oldest, and so if he passed away or decided to retire, and there's a couple others that might, but I doubt it. And all the new ones are in their 50s. So they were appointed, at a young age for a reason that they're not going anywhere. So it's 6-3 now. So it's going to take a couple of changes, and maybe something will happen. If you remember, Franklin Roosevelt was going to pack the court during the New Deal because original court was throwing out everything that he was passing. And then he wanted to pack the court. And then there's a great thing, a switch in time saved 9. Somebody unexpectedly retired, and that allowed him to appoint somebody new, which changed the whole focus, and they didn't have to pack the court. So something may happen. But the 6 people right now are very, very committed to this originalist thinking, even though it's not really originalist at times, but they're very, very committed to returning back to where they think America ought to be. And, you know, I can't say that they're not sincere in what they're saying. It's just, you know, personally, I think they're wrong, but you know, that's kind of the facts and where it is. So it's important to vote, you know, and that's what I was telling people before the 2016 election. And it just showed how important it is to vote. And I can encourage everybody to go out and cast their vote because it means something.
Yeah, thank you very much. I think that's obviously a great concluding remark. And if you don't mind me adding as a word of thanks that it also pays to get some education about this stuff.
Yeah.
So this is our, you know, our friends in K-12, you know, our teachers and folks who are working on this stuff in the schools, and teachers like Ms. Harada and then Steve Morris and the Civic Ed Center that's trying to elevate our public discourse about this. And I think we're trying to do that here at Fresno State too. And so I just want to say thank you again to Jesus, who's representing our Fresno State students and did a great job. And Moira Harada, thank you very much, and Steve Morris as well. And Judge Franson, again, it's always a pleasure to hear your wisdom. So thank you very much for this event.
Well, thank you. It was an honor. Very good. Good evening.
Bye-bye.